Good morning, everyone. Thanks so much for joining us. I'm going to wait a couple moments as people begin to trickle in to our webinar. We're excited to have you. This is our webinar on Employee Injury Claims 101, a guide to proactive management and resolution with the one and only Jason Hiller. We are so happy to have. We are going to go over a couple of things before he gets started so that everyone's on the same page. So my name is Cassie Hopkins and I help coordinate the webinars. If you have any technical issues, just reach out to me and I can see how I can help you. Jason is going to be going through a lot of content today. So we are going to ask that people save their questions for the end of the session. But that being said, if you have a question that pops into your head, you can just use the chat feature on Zoom and you can type in your question. Just know we haven't forgot about you. We're just going to answer it at the end of the session so that we can get to all the questions in a good amount of time. Also, as a reminder, this webinar is recorded, so if you want to come back to it at any point in time, you can. It'll be emailed to you along with a copy of the PowerPoint slides. And if for any reason you need to jump out of the webinar, you get that email and you can return to where you were at. We also are doing something very exclusive for this webinar. As many of you are aware, we are doing a work comp seminar for the very first time, and we thought we'd do a lovely promotion of Jason Hiller's session by offering this webinar with a discount code. So at the end of the session, we're only giving it out during the webinar. I will drop the coupon code for 50% off the seminar. So you can get half off. You can come and see all of the wonderful sessions that we'll be doing and learn even more about work comp management. So without further ado, I will introduce Jason and we'll get started. Jason joined Hausman Group in 2022 as a claims resolution strategist specializing in, guess what, work comp. Before joining Hausman Group, he was a director of safety and compliance at a multi-state temporary staffing and recruiting, HR consulting, and PEO organization. He has over 15 years of experience in workers' comp and return to work strategies, and it's given him a knack for walking the tightrope between protecting the organization and doing what's right, while also treating employees with respect and dignity. Workers' compensation has always been one of Jason's favorite focus areas, and he's excited to bring his experience and knowledge to HG clients. Fun fact, he can come up with a light-duty solution for practically any scenario. I love to hear some of those wild ones he's had to make. When Jason is not accomplishing all of this at Hausman Group, he is hanging out with his partner and his wonderful new husky and his cat. So with that, I will toss it over to Jason and we will get started. Thank you.
Thanks, Cassie. Good morning, everybody. As Cassie mentioned, today we are going to be talking about employee injury claims at kind of the 101 level, focusing on guiding you to proactive management of claims as well as getting them to resolution. From an agenda perspective, these are the topics that we're going to be looking to cover today. We'll start out with an introduction to injury claims. For lack of better words, workers' compensation claims. Sometimes I call them employee injury claims. How you initiate the claims process, some of the major milestones in the claims process, the importance of documentation and communication, and then we'll talk about some HR and employer perspectives. So to jump right into introduction to employee injury claims, I think it's fundamentally important to understand why workers' compensation exists. Workers' compensation was developed as a no-fault system to protect employees and employers when injuries happen. So, before workers' compensation existed, some employers weren't paying medical bills when people were injured at work, and on the other side, employees were suing their employers in tort court for astronomical amounts of money. So it kind of limits the employee's exposure or the employer's exposure while making sure that the employees are taken care of when a work injury happens. In general, workers' compensation is what's called an exclusive remedy, which means that, the employees' bills are paid, their lost wages are compensated. They can't then turn around and sue in tort court to kind of get another settlement. There is no pain and suffering in workers' compensation. The exception to that is if there is a negligent third party, workers' comp does not prevent that employee from going after that third party in tort court to recover damages as well, but protects the employer as an exclusive remedy. So the benefits of workers' compensation, conceptually, the goal is to indemnify the injured worker or make them whole, quote unquote. That's the definition of indemnity. Starting with their medical payments. So, most of their medical bills that are reasonable and related to the injury would be paid. Indemnity benefits or lost time benefits include 2/3 of their average weekly wage, which is not taxed, which is why it's 2/3 instead of the full wage to contemplate what they would normally be paying in taxes. I'll give a disclaimer that almost everything I'm talking about in this presentation is related to Wisconsin. Every state has a different plan. So if there's any specific numbers mentioned in this presentation, it's based on Wisconsin's laws. In most states, there is what's called a waiting period for indemnity benefits before any lost time benefits kick in. In Wisconsin, that's a 3-day waiting period. So the employee would have to lose 3 days of work before any indemnity benefits would start. Anecdotally, that's when people go to the emergency room as their initial treatment, you will see the ER doctors automatically taking people off work for 3 days because they know that's how much time they can be away without any indemnity benefits being due. Other states, I think Florida is probably the largest one I've seen, as a 14-day waiting period. So that employee has to miss 2 weeks of work before anything kicks in. Indemnity benefits are broken up into what's called temporary and permanent. So on the temporary side, they have what's called temporary total disability, which is when the doctor says they can't work at all. Temporary partial is when the doctor gives them some work restrictions that the employer is not able to accommodate, or kind of time bars them, saying you can only work 6 hours a day. So then they're losing 2 hours, per day, which the carrier would then pick up those benefits. When we're looking towards the end of a claim, start looking at permanent total and permanent partial disability. Permanent partial means they've lost a specific amount of use of the body part that was injured. In Wisconsin, this is a scheduled kind of payout. So if you lose 5% of the use of your leg at the knee joint, there's a specific dollar amount or number of weeks that is paid out for that permanent partial disability. Permanent total means that their doctor doesn't believe they're ever going to be able to work again. So that is another structured kind of scheduled payout in Wisconsin. And then we also have what's called loss of earning capacity. So if the employee is injured such that they are not able to earn the same amount of income that they did at the time of their injury, there are a number of benefits associated with that, including medical retraining, where they might get to go back to school to learn a new trade so that they can get back up to that earning capacity, and a variety of other kind of vocational rehabilitation options in that space. Disfigurement is another benefit that is in the statute. So I always use the example of a hand model. If you have a finger amputation and your career is that of a hand model, you may not be able to lucratively earn as much as you could due to the disfigurement. We see disfigurement probably most often in amputations as well as in burn cases, depending on the nature of the injury. And then there are death benefits. If the employee does pass away, there are benefits that are paid out to the surviving spouse and any dependent children. If there are no surviving spouse or dependent children, the state tends to recoup those benefits for their fund. So just because somebody is single and has no children doesn't mean there won't be death benefits due if somebody passes away. As I mentioned before, each state has their own specific workers' compensation plan. I will note Wisconsin was the first state to implement the workers' compensation law. Jurisdiction can get tricky. So if you're an employer that has people traveling to different states or different job sites from where they live or where your offices are, that can get a little bit tricky. Make sure to reach out to your agent or your carrier to talk through specific circumstances. Something to keep in mind anytime you're letting employees travel to seminars or things like that away from the standard work site. There are also federal plans for longshoremen, offshore drilling, and military bases. And I always like to mention if you will have employees traveling internationally, you want to make sure that your agent knows that because you will need to get an endorsement on your policy to cover international exposures for work comp. So what are the costs of employee injuries? I think from an employer's perspective, lost or damaged product is a large cost. So if somebody cuts their finger in a machine and there's blood all over your product, obviously the machine's going to be down for a while. That's going to slow down your productivity. An employer that doesn't have a strong safety culture could develop a negative reputation where employees don't want to work for you. And then certainly employee morale. If you're watching your coworker get injured, that's never a great feeling. And you want to know that your employer cares about you and is providing a safe work environment. Those are some of the like non-actually tangible costs or non-dollar costs. Then we get into the actual dollar cost, looking at the most common type of workers' compensation policy, which is called guaranteed cost policy, where your premium is based on your industry class codes as well as your payrolls. This is a fixed dollar amount that can be easily calculated. That is then multiplied by your experience mod rate. Your experience mod rate starts out at 1.0 for an average or brand new employer and can go above or below 1. I like to equate this kind of like auto insurance. If you get in a bunch of auto accidents, your rates are going to go up. If you have really good experience, your rates might go down. Same thing with the experience mod. If you really want to learn more about experience mod, there is a great presentation at that seminar that Cassie mentioned that will dive a lot deeper into the experience mod. But this is something that is calculated annually by either the Wisconsin Rating Bureau, or if you have multi-state exposure, that would be the NCCI on a national scale. And it's a 3-year look back window. So every claim that you have is going to affect your premiums for at least 3 more years, which doesn't include the most recent or current policy. So it actually kind of has a 4-year tail before it goes away. There are 2 kind of markets for workers' compensation. Free market is where we're marketing you to different carriers, and the carriers are voluntarily taking you on as a risk. If you are unable to secure insurance in the free market, there is also, every state has what's called an assigned risk pool. So because workers' compensation is a mandatory coverage in most states, the state makes various carriers kind of cycle through what's called a pool, where they are basically forced to take on your risk for a period of time, and all the carriers kind of share that risk over the years. And then there are some other alternate risk financing kind of structures that your agent would be more than happy to talk to you about, whether that be self-insurance, where you're kind of paying your own claims with the exception of catastrophic. There's retro plans or retroactive plans where you're basically the carrier's paying the bills and you're reimbursing them. And then there's insurance captives, which are groups of employers that kind of band together to share each other's risk and kind of finance everybody's losses. So if you're interested in learning more about any of those kind of alternate policy types, definitely reach out to your insurance agent and let them know you'd like to talk more about those options. There are also a couple types of claims that are not covered by your workers' compensation policy, where the employer is kind of on the hook to pay out of pocket. The first one is what's called unreasonable refusal to rehire. This is a situation where the employee believes because of their work injury, the employer is not rehiring them. If they are able to prove that in court, they could be due up to a year's worth of wages from the employer. And again, this is not covered by your policy, so you would be paying that out of pocket. The other one is a safety violation. This is where the employee alleges that the employer was aware of a potential violation of safety rules and didn't remedy them. This would add a 15% increased compensation on their indemnity benefits up to a statutory maximum of $15,000 in Wisconsin. The biggest defense, in my opinion, to this is training sign-off. So if you have employees working on any sort of machinery, having them sign off that they were trained and trained regularly or as the machine might change is a really strong defense to this kind of a claim. And I do want to note that the safety violation penalties work both ways, and I'll talk more about that in how it impacts the employee and their benefits in a later section. So once a claim happens, how do we initiate the claims process? So once an injury happens, the first thing you always want to do, and this kind of applies to any sort of insurance claim, is make sure that further injury is prevented. If you have a tree limb fall on your house, you want to make sure you're protecting your house so that no further damage is happening. Same thing in workers' comp, make sure your other employees are safe and that there's no risk of further injury. And then if it's an emergency situation, definitely call 911, get them treatment as quick as possible. Do not delay reporting based on your lack of information. Send in what you do know. I hear all the time from employers that are reporting claims 2 or 3 weeks after the fact that, they didn't have, one little piece of information on the first report of injury, so they wanted to hold off reporting. Just send it into the carrier, put them on notice as soon as possible. They can get the claim kind of set up with some key details, including, at the very basic level, the name, the date of injury, and what happened. They will ultimately need the social security number and date of birth, but they can still get the claim set up without all of that information. Again, notify your carrier of the injury as soon as possible. If you're not sure how to report the injury, contact your agent. They can certainly provide assistance. Here at Houseman Group, we encourage you to report the claim directly to your carrier so that you're not delaying anything by having us submit. Most carriers have an email address you can send the injury report to. Many have an online portal, a phone number, or a fax number. Some actually use nurse triage line where you can call and talk to a nurse, and that nurse will report the claim for you. And then your next step, once that's done, is to promptly complete your incident investigation. So who are the players in the carrier side with claim management? Your primary contact at your insurance carrier is going to be your adjuster. The adjuster is responsible for the medical and financial management of the claim. If you're looking at loss runs, I like to just highlight paid and reserved equals total incurred. So reserved is kind of what the carrier expects to pay on the claim. And then there's usually a line talking about expenses, and the expenses are the carrier's cost of managing the claim. And these expenses do not impact your experience mod. They are strictly the carrier's cost of doing business. Many carriers tier their adjuster structure. The most basic minor lacerations will go into what's called a medical only department. These are adjusters that have a fairly high, volume of claims that are, not having any lost time or indemnity exposure. And then, if there is lost time or indemnity, they typically will get bumped up to the next level of adjuster that's more familiar with calculating the benefits and making sure, checks are going out, nurses are engaged, things like that. And then for the worst of the worst claims, most carriers will have a catastrophic department that handles really kind of life-threatening, super bad injuries. So if you're wondering why your adjuster is changing over the life of your claim, many times it's because of the severity is either increasing or decreasing, and they will kind of pass off to the adjusters that are most familiar with those types of claims. The next player on the carrier side is what's called a nurse case manager. A nurse case manager is, as you might guess, a nurse who is helping the adjuster kind of manage the medical side of the claim. These can be either telephonic or nurse case managers or in person. The telephonic adjuster or the telephonic case managers are making phone calls, talking to the employee, talking to the medical provider's office, just really helping the adjuster obtain records and making sure the provider is in the know of what's going on with the claim. In person, field case managers will actually attend appointments with the employee and kind of do a little bit more digging. I would say that in person are for the, maybe more suspicious or the lingering, malingering people that are just kind of dragging on in their claim to really help move these forward towards resolution. And I think one of the key benefits with the nurse case managers, they can really help the injured worker understand the treatment plan and kind of what to expect moving forward. and just kind of be the liaison for that employee. All right, the next kind of player or concept is what's called an independent medical evaluation, or sometimes a medical record review. So these are what the carrier will use anytime a second opinion is needed. So both the employee and the carrier are entitled to a second opinion if they're not happy with, the way the claim is going or the diagnosis. They can request a second opinion. An IME, or independent medical evaluation, is an impartial third-party doctor. Typically, they are specialized in the body part or nature of injury that they're being used for. And they will give an opinion on the nature and extent of the injury, as well as if it's work related and how necessary ongoing treatment is. One thing to keep in mind is that IME doctors do not actually treat the employee. They are simply reviewing all of the medical records. And if it's an in-person IME, they will actually meet with the employee and do some kind of diagnostic, or have a meeting with them to hear about what's going on, see how far, like what their range of motion looks like, and then give an opinion based on how the injury was reported to have happened. And then the last kind of the closing out of the claim, we get to where we're talking about vocational experts. This is uh, an expert who is evaluating the injured worker's ability to secure gainful employment in the future with or without retraining. Um, they assist in identifying retraining resources. So they'll meet with the employee, find out what skills they have already, what skills they might be interested in gaining if they can't go back to the type of job they were working in before. And then they will assist in job placement activities if the position is no longer available at the employer. Also, a lot of these vocational experts are a good resource for the carriers to leverage for third-party light duty partnerships. So many times, if an employer is unable to accommodate an injured worker's restrictions, the carrier can leverage this company to help find a placement in the community that can accommodate while they're still temporary, while the employer pays the wages to avoid additional indemnity payments. There's a number of reasons why getting employees back to work, beyond the financial benefits of the experience mod, just having the habit of getting up every day and coming to work, it is really good for the psyche and keeps them in a more positive mindset. Also, if they don't particularly love their light duty placement, it may encourage them to get better faster so they can get back to their original job. But these voc experts are super helpful in a number of scenarios. All right, so what do the milestones in the claims process look like? So first of all, the initial treatment happens, right? So they get to the ER or to their occupational health doctor. The first step the carrier is going to do is to complete a compensability investigation. Talk about that in just a second, about what the requirements are for a compensable claim. So they do that investigation. Your first goal or milestone in the claim is return to work in some capacity. We want to get them back to work, whether it be at full duty or in some sort of restricted duty or light duty. Restrictions can be either physical or time-based, such as only 2 hours a day, or can only stand for 4 hours a day, things like that. Just getting them back to work in some capacity should be your first goal. And then progressing back to full duty, getting to the end of healing, which is when the doctor says you're as good as you're going to get, and they will typically discharge them from care, saying there's no more treatment that would be helpful. This is when the doctor will address any permanency related to the claim, any vocational retraining needs, and then, as we talked about before, the loss of earning capacity. And for certain individuals, Medicare has to be a consideration, where the government doesn't want to pay for work injuries. So a lot of times if the person is Medicare eligible, there'll have to be a Medicare set aside in case any bills related to this work injury trickle in over the years after it closes out. So initial treatment, return to work, end of healing. Those are kind of your 3 milestones that you're shooting for to get claims closed out. So what are the requirements for a compensable workers' compensation claim? Number 1, must be a W-2 employee of the insured employer at the time of injury. Things to keep in mind: independent contractors, subcontractors, Highly recommend if you're hiring subs or temporary employees or third-party employees that you're requesting certificates of insurance to make sure that those subs have workers' comp coverage for their employees, because if they don't and an injury happens, very easily the state could bump that up to your policy as the kind of next in line when they're looking for coverage. So highly recommend certificates of insurance anytime you have people that are not your W-2 employees working for you. And then we get into kind of the legalese side of the claim. So an injury to be compensable has to be by accident or occupational exposure. And I think accident is a key word here. And it has to arise out of and be in the course of employment. So looking at the term arising out of, that would be the cause of the injury. So by being at work, they were at increased risk or greater risk than the general public. Or if there was an actual risk, like the pinch point on the machine or the knife or the that they're working with in the restaurant, or a positional risk where the injury would not have happened but for their employment. So had they not been at work, they never would have been injured. So those are the kind of three tests to look for the arising out of concept. And then in the course of, which is related to the time, place, and circumstance of the injury, want to look at the inside versus outside employees. So people that are working in the office all the time or in the factory versus outside, like sales employees that are traveling all the time. That's something that can make a difference. Coming and going. So when people that are driving to or from work, this is where the inside versus outside employee concept comes into play. If I work in my same office every day, I drive to work the same way, go home the same way. If I get in a car accident on my way to work, that is not considered work related, not in the course of employment. However, if I'm a sales employee whose job requires traveling all over the place and I'm driving all the time, or my work site changes on a daily basis, some of those coming to and from work accidents can be compensable. It's all very fact specific. Personal comfort doctrine. This speaks to maybe I'm going to the restroom and I slip on a wet floor in the restroom. So while I'm not really doing anything for the benefit of the employer, there's a case to be made that if I wasn't allowed to go to the bathroom, my work wouldn't be so great. So, so I'm just by making myself more comfortable, the employer is receiving a benefit. Also see this applied in things that happen kind of on paid breaks or things like that. Traveling employees, so anytime your employees are traveling for work, basically for their normal working hours. So if I'm an 8 to 5 employee, I go to a seminar. Anything that happens kind of in that 8 to 5 space could be deemed compensable. So always want to make sure you're keeping an eye on your employees while they're traveling because you could have work comp exposure. I've even seen claims where an employee gets food poisoning at a restaurant that they were eating at a seminar, and that was considered compensable. They wouldn't have been eating at that restaurant had they not been traveling for this work conference. And then deviation, anytime, and this kind of comes back to that coming and going rule as well. You're deviating from your normal path to, like, I'm coming to work, but at first I stop at the bagel store to pick up bagels, right? That's, I'm bringing those bagels to work. Something that happens in the bagel store could be deemed workers' compensation. So I think the rule of thumb here is always know where your employees are going if they're not in their normal work site and what they're going to be doing while they're there, so that you can really evaluate the risk there. All right. In order for a claim to be compensable, the injured worker must sustain a quantifiable loss as a result of the work incident. This could be financial, in the form of medical bills or lost wages, especially and loss of consortium means that, maybe they're the sole income provider for their family and they're no longer able to do that. Um, so that could be another quantifiable loss for the family. Oops. Pre-existing conditions, this is something that I think comes up all the time when people injure, their back, right? Do they have a pre-existing back injury? If there was a specific acute work injury, that's a little bit easier to determine. But what we're going to be looking at, was this an aggravation of that pre-existing condition, or was it exacerbated beyond its normal progression? So did it get significantly worse because of the work injury than it would have in normal circumstances? Um, I hear the concept, take them as you bought them, a lot in workers' comp. So if you're hiring somebody that has, a pre-existing condition, you're getting them as they were when they started working for you. Um, the thing to remember though is you have to return the person to their pre-injury state. You don't have to necessarily get them back to 100%. So if they had a degenerative condition already, hopefully there's some medical records that show kind of what that condition looked like before the work injury, and then you have to get them back to that point versus completely healing the injury. Um, a lot of employers will say, well, how would I know if somebody has a pre-existing condition? I think the strongest way to determine that is by utilizing various pre-employment screening techniques, whether it be post-offer physicals or things like that. But really, and certainly doing a thorough screening as you're interviewing people, finding out kind of what their past work history is, what was the physical nature of their prior job. Those are all kind of clues that you might get to determine whether or not somebody is physically conditioned to do the work that you're looking for. All right, so on to the employer defenses. So what defenses do employers have once an injury does occur? The first one I like to look at is idiopathic injury. So this basically means nothing in the work environment caused the injury, and they were at no increased risk than the general public. So this could be something like a heart attack that was unrelated to work. This could be I'm just walking on a flat surface and trip on my own feet. They could have done that anywhere. So that's the first defense that we kind of look at. Any sort of hazard in the work environment is going to take that to a different place. So if there's water on the floor and they slip on the water, that's a hazard. If they're climbing on stairs at work, pretty much stairs are always a hazard, things like that. So it has to be purely personal in nature with no increased risk from being at work. Intentional injuries are not compensable. Again, that term that we talked about before, accident, it has to be an accident. So and this can be kind of hard to prove in certain circumstances, but if you think that person shoved their hand into the machine on purpose just because they don't want to work, that can be a defense. That's a situation where, witness statements could be certainly helpful, or any other documentation that you have to prove that it was intentional. Coming back to the safety violation that we talked about before, and this is why doing training again is super important and having sign-offs on that training, if we're able to prove that the employee violated a known and enforced safety policy, they could be subject to a reduction in their benefits of 15% up to a $15,000 statutory max in Wisconsin. So I see this fairly common with lockout tagout injuries where, you're doing lockout tagout before they're allowed to do it. Maybe they've had some retraining on lockout tagout. They've had a prior warning for not following lockout tagout, and then the next time they get injured, we can provide all that documentation to the state. The state would potentially allow a penalty of 15% on their indemnity benefits. And there is also a defense around drug and alcohol use. This one can be somewhat hard to prove as well, but there has to be a known and enforced drug and alcohol policy. And this is the part that's hard to prove, a direct correlation to the injury. So you have to be able to prove that the use of drugs or alcohol was a direct cause of the injury. And in this case, this would include a full forfeiture of their indemnity or death benefits. However, medical bills would still be covered. All right, talking about proving things, let's get into documentation and communication. In almost every state, the first step is to fill out what's called a first report of injury form. These screenshots are from the Wisconsin first report of injury. I've put stars next to the particularly important pieces of information. The top portion of the Wisconsin form is all about employee demographics, their name, their social, phone number, address, birth date, date of hire, and then your information as the employer. Those are the key pieces of data here. Again, if you don't have the social or birth date, get the claim in. The carrier will contact you to get that down the road. And then the middle portion is all about wage information. I like to tell people, because this is probably something that the day-to-day person who's sending in a claim might not have access to all of this wage information. This is not typically required unless there's anticipated lost time from work. So again, if you're going to skip any portion of the first report of injury, skip this part, just skip the claim in. If they need wages down the road, they will certainly reach out and request them. You'll see there are some questions about part-time employment. Um, I want to encourage you, if you have part-time employees that are part-time because they want to be part-time, that you get something in writing from them. Because many times if an employee is injured and they're a part-time employee that it hasn't specifically requested to be part-time, their wages could be bumped up to full-time wages just because they probably can't work at their other job as well. But if you have a signed statement from them saying, I'm the one self-selecting to be part-time, that can be a defense to keep their wages restricted to what they would have actually earned from you in their part-time position. And then the bottom portion is all about the injury. This is where getting as much detail as possible is super helpful eventually. But if you don't have anything beyond the injury date and some very loose details, just get that on the form, get it sent in. You can always provide more detail later once the claim is set up and running. All right, so then you move on to your prompt incident investigation. The purpose of this is to gather relevant details for the work comp claim, and depending on the severity of the situation, you may need those details for OSHA. Certainly to prevent future injury to this employer, to your other employees, as well as to identify possible negligent third party for purposes of subrogation or recovery. You want to gather information as soon as possible after the incident, and certainly recommend investigating near miss situations because there's only so many near misses you're going to have before the injury actually happens. As far as who should conduct these investigations, certainly the injured worker's direct supervisor is probably one of the best people to kind of have the intimate knowledge of the day-to-day job that was being performed. If you're a larger company, you may have a safety professional that would conduct the investigation. Certainly, you could also leverage your carrier or your insurance agency, tend to have loss control resources that could help you with that investigation as well. And then many companies, the investigation falls on the HR department. So when I'm talking to folks about doing incident investigations, your goal here is to identify the root cause of the injury. Like, why did that injury happen? So getting specific details about what happened and what happened leading up to the injury. With the more detail, the better. Again, going back to the who, what, when, where, why. Exploring if there were any safety violations or progressive discipline that had been in place before. And then I always talk about asking why 5 times, and we'll talk about that in just a second. The longer you wait to secure photo and video witness evidence, the more likely is that will not be accurate. Thinking about video surveillance, a lot of times that gets erased within a certain time period. Employee memory can change, so just getting as much as you can right away when it happens. Certainly, again, making sure that the employee is getting the treatment they need and that their further injury is not going to happen. Super important. Timely witness statements, getting people to write down what they recall, sign and date it. Those are key pieces of evidence as claims progress into litigation. All right, detail, detail, detail. So I thought I'd provide some examples of starting out with poor example of an incident investigation or injury description. Here we have John fell the other day and hurt his leg. So that's pretty vague, right? So why did he fall? What day did he fall on? Which leg did he hurt? What is the actual injury? Did he twist his ankle? Did he dislocate his knee? Kind of getting all of those details is super important. So this slide has what I would call a better example of a thorough, incident explanation. At 9:03 a.m. on Wednesday, July 5th, John Doe was walking down aisle B in the North Warehouse when John stepped up on a pallet that was in his travel path. The pallet buckled, sending John's right foot through the wood, causing John to lose his balance and fall down. John's right ankle was cut by the pallet wood, and John landed on his right knee. He became very swollen and discolored. So you can see how you can almost visualize that injury happening by this description. And that's kind of my rule of thumb is like, if I can't visualize that injury happening, I'm going to want to ask more questions. So getting to the ask why 5 times. So why did this injury occur? Well, John tripped on a pallet. And why did John trip on a pallet? Because the pallet was in the aisle or travel path. Why was it in the travel path? Because the person who emptied the pallet didn't remove it. Why didn't they remove it? Because they had another pallet to unload in the next aisle. Why were they rushing so much? Because they're short-staffed due to illness or employee turnover. So in this case, we've identified the root cause of John's injury because the employer is short-staffed and everybody was rushing. Just encourage you to be curious. Don't just take an injury at face value. Try to figure out what happened, why it happened. Um, you could go even further in this case. Why was the pallet in poor repair causing it to buckle? How fast was he walking? Could he have walked around the pallet, or was the aisle too narrow? What footwear was he wearing? I mean, you could keep asking questions more than 5 times certainly, but I think 5 is a good rule of thumb to get you to that. So once an injury happens, there are some mandatory reporting requirements that I'd like to make sure everybody's aware of. In Wisconsin, DWD, Work Comp Division, requires any fatalities be reported by phone or fax to them within 24 hours. You can certainly find this information on the DWD's website, but it's here on the slide if you need it. And then OSHA also has some mandatory reporting requirements. Any deaths need to be reported to OSHA by phone within 8 hours. And within 24 hours, you need to report any inpatient hospitalization. Put the caveat on here, besides observational inpatient hospitalization. So they have to be hospitalized for treatment, not just for observation. Any sort of amputation needs to be reported within 24 hours. I typically look for bone loss to be considered amputation. Some people might advise differently. If they're just losing like flesh on the tip of their finger, I'm looking at that more as an avulsion than an amputation. But if you have never talked to OSHA, OSHA really likes employers that want to comply with their rules. So never feel scared to call them and ask a question, or contact your agent. Here at Hausman Group, we have some OSHA experts that are always happy to advise on these types of mandatory reporting situations. And then anytime somebody loses an eye, OSHA wants to know about it. So just make sure you're making those contacts within 24 hours. All right. And then my last kind of topic here is the HR and employer perspective in workers' compensation. I have a feeling that the majority of you are employers either in the HR or safety space. So just kind of want to talk about different roles and how they play into the claims process. So the role of HR and management varies by organization. I think from my perspective, the primary role for HR and management is to manage the insurance relationships, whether that be policy renewals, submitting the claims, providing payroll information, and things of that nature, and to help guide the manager in investigation and follow-up. I always recommend the best practice is having the direct supervisor as the primary contact for the injured worker. This really demonstrates does my manager and the organization care about me? I think we all know HR has that, oh no, HR is coming kind of mentality. And, the last thing we want is for the employee to kind of put up that wall at the beginning of a claim. They're going to be more kind of conversational and share more openly with their direct supervisor, person that they work with on a daily basis. I will tell you that workers' comp is typically one of the biggest spends that businesses have as far as their business insurance. So it's really important for most organizations to manage those costs effectively. Other roles HR can play, certainly coordinating benefits related around the injury, One thing that I see that is kind of an unintended consequence when people are off work due to a work injury is that, they may lose their employee benefits because their premiums aren't coming out of their paychecks. So that's something to just be cognizant of. You don't want your employees to lose their benefits while they're recovering from a surgery or something of that nature. Also, there are always, not always, but typically FMLA or ADA implications as well following a work injury. And I think HR and management can take over when claims start to escalate. If there's a fatality, obviously you want HR involved. If the employee quit or was discharged from employment, having that ongoing relationship with their manager isn't as crucial. And certainly if there's any sort of litigation, you want to kind of streamline that communication to one point person in HR or management. I like to bring up Maslow's hierarchy of needs in the workers' comp kind of space, just as something to think about. We all think a lot of people have skepticism when people report work injuries, but you also don't want to have a negative stigma in your organization about reporting when things do happen. And just kind of leading the claims process with empathy with your injured worker is only going to positively impact your outcomes. So if you think about what happens when an employee is injured, especially in maybe a lower wage earning position, you know, the the first thing running through people's head isn't how am I going to screw my employer over and get as much money as possible. The first thing that goes through their mind is where am I going to sleep tonight? How am I going to feed my family? Um, and will I still have a job after this happens? So again, having that empathetic manager leading the conversation, letting them know that the employer and the manager care about them and want to help them get back to better, will certainly help the psychological progress of the claim and kind of keep the lines of communication open and ultimately lead to better medical outcomes. Um, this is something I've been sharing, I think, more and I've been hearing in the workers' comp world more in the last couple of years. And honestly, there's some interesting progress with AI in the world where sometimes I think, you know, AI could maybe be a little bit more empathetic than claim adjusters sometimes. So it'll be interesting to see how AI is used in the insurance space moving forward. But um, definitely lead with empathy on your work injuries will lead to better medical outcomes. I am always available for questions if you want to call or text me. My phone number is here on the screen, and certainly my email address, jhiller@myhouse.com. Reach out anytime. Happy to answer any questions there. And then, as Cassie mentioned at the beginning of the session, we do have our inaugural HR or HG Workers' Compensation Seminar coming up on September 24th. It'll be 8:30 to 3 o'clock at the Edgewater Hotel. We do have it broken up into a morning session and an afternoon session if you're interested in kind of the more basic understanding of work comp basics, which will be very similar to this presentation and the experience mod. Morning is for you. You want to dive a little bit deeper. We have some great panels in the afternoon with some Wisconsin employers talking about some of the programs that they're running in their organizations and the benefits they've seen from those. And then we will have a table read of various claim types with some experts in the workers' comp field. We have a defense attorney on that panel, a claims manager, a risk control consultant, and myself. So love to have you there if you're interested. It is approved for 4.5 HRCI and SHRM credits. And as Cassie mentioned, we are offering anybody that's attending this webinar a 50% off discount code, which she will drop in the chat. I do know that space is getting a little tight, so if you're interested in joining the seminar, I encourage you to jump on that sooner than later. And certainly give me a call or shoot me an email if you have any questions on the seminar.
Thank you, Jason. We did have a couple questions come in chat, and I will just reiterate some things about the work comp seminar. If you look in your chat right now, so if you click chat, There is a code for me that says code for 50% off, and it's house off 50. And house is spelled like Houseman, Haus. It's case sensitive, so please make sure you put it in all caps if you are interested in using that to attend either the morning or afternoon or the whole session. Either way you want to use it, it can be used for 50% off. And yes, we actually boosted our capacity for the event, so we can't boost it anymore, and we're still running out of seats. So if you are interested, I would just pull the trigger. You've got 50% off. Better to get it than not get it, I would say. So with that in mind, let's chat about some of the questions that came in. So here's our first one. If a person has a report only injury, should we turn in the first report of injury to workers' comp, or just keep it in case it escalates? Does it impact our mod rate if we turn it in?
That is a great question and one that I get quite often. I guess I would say my best practice would be to turn it into the carrier, or at least send it to your agent as a record only. It has no impact on your mod. If you do turn it in, it will stay on your loss run as a $0 claim. So it really doesn't have any financial impact to you as long as it stays record only. Um, I think it makes things easier if things escalate down the road that the carrier's already been put on notice. So you have that claim already established, which is one of the reasons why I recommend it as a best practice just to turn it in. I also think if you're using your loss runs as a kind of risk control tool as well, you can see where your near misses are, as well as your bona fide injuries. So I recommend turning it in. Ultimately, it's your decision. It's not required.
Good answer. We have another question. Do you have any recommendations for when to have a dedicated safety manager type position, such as company size or industry?
Ooh, that is a great question. It, I think there's always a great opportunity to have a safety function, whether it be part of somebody's job or a dedicated safety manager. I think obviously manufacturing is important in construction. I think both of those industries certainly would behoove you to have a dedicated safety manager. Um, but there are also resources, like I said in the presentation. If you are a smaller organization, lean on your insurance providers and your agents to help you with resources that you might need, because we want you to have good experience as much as you do. So
Right.
um, I guess that's kind of dodging the question, but I don't have a specific number of employees or specific industries. That's just kind of where my gut tells me might be most beneficial.
Here's some more questions. So we got two more for the part-timers. Does it work if they applied for a part-time only position, or do we need to have something else?
Um, you need to have something else, is the short answer. What the state wants is a specific statement signed by the employee that they are kind of self-limiting their hours. And it doesn't have to be, you don't have to get it from every employee. You could certainly implement that into your injury reporting process, that if the employee is filling out an injury report and that they're part-time, you could have them sign it at that point stating that their hours are restricted on their own. Um, if you want to talk about specifics, happy to do that, after the presentation, but just by virtue of applying for the part-time job is not self-restricting their hours, I guess.
Very nice. Next question. What would constitute a quote red flag on a claim when asked by an adjuster?
I mean, when I was on the employer side, I said every claim was a red flag. I mean, I think anything beyond somebody saw this person cut their finger off, where we know that there was an injury. If there's any sort of doubt that the injury occurred or that the injury was as severe as it's being reported, if this person has a negative performance history in the past, or things like that, anything that would make you question the nature or severity of the injury, I think would be a red flag. But I also I think the adjuster should be investigating every claim. So I would tell them, you know, barring that very obvious, we saw it happen and no, it was bad kind of situation, I would encourage them to investigate further.
I can tell you are a very thorough claims adjuster in your past life. I'm not quite sure what this person asked, so I'm wondering if maybe you can decipher it. Can you share the mandatory postings for work comp in the state of Wisconsin in the workplace?
I guess, are you asking me to send them to you, or are you asking if the
I'm
employer
wondering
is
if
supposed to post them?
I think it's different. I think they're asking if they share it in the workplace. Should they share the mandatory postings for work comp in the state of Wisconsin in the workplace?
I think most employers will just post it with all of the other mandatory postings. Like most, a lot of companies will have like an all-in-one kind of employment poster. Certainly put it there, or you could put it in the break room. I mean, you can really, as long as it's visible to all of your employees in some way, I think that's what the state is really looking for. And
Lovely.
if you're looking for the posting, ask your agent or your carrier and they can get that to you.
Perfect. Well, that's all the time we have for questions. And that was the last question. So that works out
Yay.
perfectly. Once again, if you have any questions, Jason's sharing his contact information, and everyone who registered, not only just attended, but were registered for this, will receive a recording of the webinar as well as a copy of the slides. And that will include Jason Hiller's contact information if you think of anything in advance. So thank you all. Be sure to write down that code if you are interested in using it. And thank you so much and have a wonderful rest of your morning. We appreciate you joining us.
Thanks, everyone.